and welcome back. You're listening to Passing the Baton. I'm Jared Height from Tracktown Law, and today we're talking about a question I hear more often than I'd like. Can't I just do my will online? Well, you can. You can also cut your own hair, file your own taxes, and build your own deck. But sometimes what looks like savings up front becomes structurally questionable down the line. Estate planning is no exception. A brief disclaimer: I'm a licensed attorney in Oregon and Idaho. Listening to this podcast does not make me your attorney and does not create an attorney-client relationship. For personal legal advice, please speak with a qualified professional. This is the whole point of today's episode. Let's start with what these DIY form companies promise: simplicity, speed, and savings. In theory, you just answer a few multiple-choice questions, click download, and your estate is handled. No lawyers, no meetings, no pants. It sounds convenient, until you realize that estate law, especially in Oregon, is powered by nuance. Small nuances. Quiet, costly nuances. Templates often fail to track Oregon's ever-evolving laws. They miss updates to witness requirements, overlook small estate affidavit thresholds that have changed twice recently, and ignore things like transfer on death deeds or Oregon's very specific probate procedures. These aren't obscure legal footnotes, they're landmines. A local attorney knows how your county's probate judge interprets them, your template does not. Execution errors are the silent killers of DIY estate plans. Oregon demands 2 disinterested witnesses, meaning people who aren't inheriting anything, and they must sign in your conscious presence. Use a spouse, child, or neighbor who's named in the will, and you might invalidate the entire document. Use a notary instead of witnesses, and the judge may toss it entirely. Use both, and you might get a gold star, but only if the notary isn't also your niece who's inheriting the house. At my firm, we supervise signings like it's a legal ceremony. Blue ink, 1 staple, initials on every page. Why? Because in probate court, appearance matters. A will signed in black ink with no initials and pages that look recently reprinted raises eyebrows, and eyebrow raising in court usually costs 4 figures. Then there's customization, or rather, the lack of it. DIY forms are designed for fictional standard families. Yours probably isn't one. Blended families, children from prior marriages, heirs with disabilities, pets who outlive half your relatives. These things don't fit nicely into checkbox templates. A lawyer can write clauses that make sure Maple the rescue dog ends up with the right person, and that your spouse doesn't accidentally disinherit your kids from a first marriage. Taxes are another blind spot. As discussed in the last episode, Oregon still has a $1 million estate tax threshold, unchanged since 2012. That might sound high, but between home values, retirement accounts, and life insurance, many middle-class families cross it without realizing. A lawyer can preserve both spouses' exemptions through a credit shelter trust. Most DIY forms don't include that option, or worse, include it in generic terms that won't hold up in Oregon court. It's like buying insurance from a vending machine. Technically possible, not recommended. Then there's trust funding. Many DIY kits include a revocable living trust, but never explain the crucial step: moving assets into the trust. Your house, your bank accounts, your brokerage assets, if those aren't retitled into the trust, it's just a beautifully formatted folder gathering dust. I call it the empty box problem. It looks like a gift, but there's nothing inside. When you hire a lawyer, you're not just buying a document, you're buying a system of double checks: review, funding, execution, storage, and follow-up. If your documents fail in court, malpractice insurance stands behind them. If a DIY form fails, the company will cheerfully remind you that you waived all liability when you clicked on Accept Terms. And let's talk about pricing. DIY services advertise will kits for $99 or complete estate plans for $3.99. But then come the upsells: subscription storage, attorney review, and add-ons that still don't solve the biggest problem: your plan may not work when it matters. A real law firm, mine included, quotes flat fees for most plans. No surprise charges, no hidden terms, just legal documents drafted to actually function in Oregon, not just appear legal-ish. Here's the truth. Estate planning is not a form, it's a conversation. When you meet with an attorney, we don't just fill in blanks. We listen for hesitation. We ask about family dynamics you didn't know mattered. We flag the adult child who shouldn't manage money, or the nephew who should never control your medical decisions. You don't get that nuance from an algorithm. If you've already used a DIY kit, don't panic. You're not alone, and all is not lost. Bring it in. We'll stress test it, check the signatures, and tell you if it can be patched with a codicil or if it needs to be redone from scratch. Most fixes are cheaper than fixing a failed probate down the road. Think of hiring an attorney like hiring a certified electrician. You could try rewiring the panel yourself, and the lights might turn on, but hidden behind the drywall, a spark waits, and it won't be your problem, it'll be your family's. Your estate plan has one job: to work when you're not around to explain it. That's not the time to find out the software had a bug. So if you're ready to stop hoping your template holds up and start building a real plan with professional guidance, visit tracktownlaw.com. I'll walk you through the process, quote you a flat fee, and draft documents that actually reflect your life, not someone else's checklist. Next episode, we tackle how Oregon's estate tax interacts with the federal system and how to avoid paying more than your share to both.